lead counsel is Tom Leach QC, assisted by Stuart Harrison, David Snells and Mike McCray.
Quite a cast, yes. Yes, Mr. Flynn.
Although we submit that Deyaar and their new legal team bear the burden of proof on all the issues which arise at this hearing, it appears they consider we should go first. And if your Lordship is content with that,
Yes.
given the amount in writing, I can deal relatively briefly with the issues from our perspective.
Right.
Now, I think the starting point is that your Lordship might be forgiven for thinking that this case was substantially concluded. That was certainly our view, and the view of National Bonds, and indeed Deyaar's former legal team. And it is somewhat surprising that despite 2 weeks of trial and around 300 pages of submissions, your Lordship now has another 80 or 90 pages of notes and submissions to wade through. I hesitate to ask, did your Lordship manage to read at least the skeletons and the material on our reading list?
Yes, I fear there was a breakdown in our electronic system, and I'm afraid I didn't actually see the skeletons for this hearing until this morning, but I have read them, although perhaps more hurriedly than I usually would. But that is all I've read.
Well, I'm very grateful, my Lord. In that case, I will take you through what we say. The starting point is the draft order from Deyaar. I won't take you to the terms of it, but according to Deyaar, it is entitled to the return of the premium and to its costs for the trial. And that is despite the fact that every live issue decided in your Lordship's judgment was decided against Deyaar. Now, clearly, Deyaar has changed its legal team, and in those circumstances, it is only natural to look with hindsight at what went before and ask, why didn't they take this point or that point? And in those circumstances, it may be tempting to push the boundaries a little of what is and what is not open for further argument. But in this case, we would submit that Deyaar has overstepped that mark by quite some margin. And the strong impression one gets from reading Deyaar's submissions is that they have resolved to take every possible technical point they can think of to resist the orders sought by Taaleem and National Bonds, paying little or no regard to whether or not those points are open to them. Now, it is our submission that all of the issues which they have raised have either been decided in the judgment implicitly or explicitly, so that Deyaar are bound by those findings on the basis of strict issue of estoppel. And we submit, in fact, all of the issues fall foul of strict issue of estoppel, but even if they don't, they cannot raise those arguments by reason of abuse of process by application of the rule in Henderson and Henderson. Now, in some instances, the points taken are obviously and demonstrably wrong. Some are based upon an express submission that your Lordship's findings in the judgment were, and I quote from their skeleton, not appropriate. Now, we submit that it is their approach which is inappropriate, not your Lordship's findings in the judgment. Indeed, Deyaar even suggest that Taaleem is shut out from responding to some of their points because it's too late to do so. Now, we submit that the position is quite simple. Firstly, the key issues in this case have been decided in the judgment. Deyaar sought permission to appeal on the basis that they had lost, and they failed on both on paper and at the oral renewal stage. Secondly, it is simply not open to them to run the points it now seeks to raise, and that's because they're either, as I say, subject to issue of estoppel or abuse of process. So, for example, they raise a large number of points, but Deyaar says that the contract is unenforceable because it is impossible to perform, or is void because formalities were not complied with. Now, none of that is open to Deyaar, because your Lordship has found that there is a binding contract, and it is too late to introduce those sorts of issues. They are a collateral attack upon your Lordship's judgment. If there is anything left to decide, and we submit there isn't, but the answers are plain. Firstly, there has already been a transfer, and we say that that is a plain and simple solution to the matters now advanced in this application by Deyaar. And if your Lordship agrees with us on that, that's an end of the matter. None of the points arise. But secondly, even if there hasn't been a transfer, the court should order it. Now, if your Lordship is not with us on either of those two solutions, there will need to be an assessment of Taaleem's damages. And we submit that would be unfortunate, and it's essentially an say your lordship did, and why. So in terms of issues decided, it's our submission that all the issues which concern Taaleem have been decided in your lordship's judgment. Now, to remind your lordship, Taaleem's case was that the contract dealt with 4 different aspects of the transaction. The first was the interest in Sky Gardens, and that was a beneficial interest under a trust. The second were the obligations arising under the tripartite agreement, most significantly the obligation to pay for the interest. Thirdly, the premium. And fourthly, the liability of Taaleem to national bonds. Now, taken together, those were the 4 elements of the transaction. But by the time of trial, only 2 were relevant. The premium had been paid, and following the reduction in the scale of the transaction in April 2009, Deyaar had paid off the remaining debt under the tripartite agreement. So the only remaining elements were the interest in Sky Gardens and the obligation to repay national bonds. And your lordship may recall that, as advanced by Mr. Knowles at trial, the key issues were essentially twofold. Firstly, was there a binding contract? And secondly, if there was, should it be set aside, for want of a better phrase, breach of fiduciary duty, or at least something akin to that in the way it was advanced by Mr. Knowles? Those were the 2 key questions. Everyone acknowledged at the trial that there might be 2 ways in which a contract might have arisen. There might have been a transfer of some or all of those elements. Alternatively, there might have been an agreement to transfer some or all of those elements. Now, on our reading of the judgment, those issues have been answered with more than sufficient clarity. And as I say, if we're right about that, that's the end of it. So I would just like to remind your lordship of the judgment, which is in bundle 4, page 292. Judgment starts at 292, but the first paragraph I'd like to take your lordship to is at 78 on page 300.
On page.
308.
Thank you. Yeah.
And what that says is the scope of this threshold issue narrowed significantly during the course of the hearing. Taaleem had opened their case on the basis that a contract was concluded at some stage between December 2008 and May 2009. As finally presented, Taaleem's case was that a contract constituting an unconditional transfer of its rights and obligations in regard to its share of Sky Gardens came into existence when Deyaar paid the premium on the 4th of December 2008, such being a non-refundable portion of the agreed consideration. And then if your lordship goes down the page to paragraph 83, what your lordship decides is, in any event, I accept the submission made on behalf of Taaleem that the whole concept of an option only exercisable following the completion of due diligence is inconsistent with the contemporary documents. The transaction was to proceed by way of an amendment to the tripartite agreement, the final draft of which was available by the 20th of November 2008. This made provision for a transfer of Taaleem's interest against payment. The payment of the premium was recorded as payment for acquisition in Deyaar's accounts and as payment for sale in Taaleem's receipt. And then if you go on to the next page, 88 to 89, the lordship says, 88, the final feature which renders Deyaar's case on the MOU impossible to reconcile with the evidence is its inconsistency with the conduct of the parties in the wake of the chosen date of the 9th of December 2009. After paying the premium, Deyaar went on to make payments of 114 million dirham to third parties in respect of Sky Gardens. In Deyaar's case, these would have constituted voluntary payments by way of reduction of Taaleem's obligations. Yet it was common ground between the experts that the recovery of such payments, if the transaction was not concluded, could only be sought as a matter of law if either they had been requested by Taaleem or completed by necessity or custom. Taking at face value Deyaar's concern that Taaleem might not be good for the premium, it is inconceivable that Deyaar would have volunteered a further 114 million. In reality, Deyaar recognised its responsibility in lieu of Taaleem summary, therefore, the position is, in my judgment, that as stated by Mr. Azam, there was a concluded agreement for a transfer of Taaleem's interest in Sky Gardens to Deyaar on the 4th of December 2008, and your Lordship sets out a number of reasons, but in particular H, there were no conditions to the transfer. Now, we submit that those are findings that both the interest and the obligations to national bonds were transferred. Now, clearly, as in any judgment, some of those findings are implicit, but that doesn't mean they are not findings or that they can be ignored. So some of the statements have to be unpacked. So where your Lordship says, in reality, Deyaar recognised its responsibility in lieu of Taaleem to make the payments, that means that Deyaar became responsible for the payments to Amlat Finance and national bonds, and Taaleem stopped being responsible for them. And this finding is only consistent with a transfer of those obligations. And as I showed your Lordship in paragraph 93, as to interest, your Lordship expressly found that there was a completed transfer. Now we say, when you take all of that into account, that isn't ended. The court can make declarations to that effect, which is what we seek, and the rest of the questions are issues between Deyaar and national bonds. And we also submit that any objective reader of the judgment would reach that conclusion. But it would be all the more clear to a party which attended the trial, as Deyaar did. Now, as I mentioned earlier, Deyaar says in the skeleton that it was not appropriate for the court to make a finding that there was an assignment from Taaleem to Deyaar of the interest or of the obligations to national bonds. That is an extraordinary assumption, given that there has already been a failed attempt to appeal the judgment, and that would be the only means by which that could be rectified. Even if there were valid criticisms, which we do not accept there are, it is far too late to raise them now. The formulation of findings being not appropriate expressly acknowledge that findings have been made by the Commission, and the only legitimate route to challenge those findings is to appeal, which Deyaar have done and failed. And we would also submit that those conclusions are entirely consistent with the way the transaction was understood throughout. Taaleem would step out and Deyaar would step in. So that is the first point, and also the final point of our submission. Everything has been decided by your Lordship. There has been a transfer, and that is the end of it. Now, on the point as it being too late, we submit that even if these issues have not yet been decided, and I pause to say we simply do not understand there can be any legitimate answer to those submissions. Your Lordship has decided it, that's it. But we will deal with the issue just in case, on the alternative basis, which we don't accept, that some issues have not been decided. It is too late to raise those now. Deyaar approached the trial on the footing solely that there was no binding contract, and that if there was, it should be set aside. Now, it's important in our submission to have that in mind when analysing their new case, which is in substance an attempt to reopen and re-argue the liability issues. But the substance of their pleading case was exactly that. No binding contract, alternatively, if there was, it should be set aside. And that was all that was in issue. Deyaar relied on the terms of the MOU and claimed that no other agreement was concluded. Now, I'll just summarise for your Lordship what they now say. What Deyaar's present position is, firstly, as to the interest in Sky Gardens, a transfer of the beneficial interest must be in writing. Secondly, in this case, a transfer required the prior written consent of the other parties, DIFC Investments and Amlat Finance. And consent was not given until April 2009. As to the obligations to
the DIFCC and who's the other?
and Amlat Finance.
No, Amlat. Yeah.
Secondly, as to the obligations to national bonds, they say national bonds didn't consent to the transfer in writing until the 12th of April 2009, and possibly on the facts, Deyaar did not agree to take any obligation to national bonds. Thirdly, they say, so far as specific performance is concerned, that specific performance should be refused for three reasons. Transfer was impossible because the deal changed Secondly, the law requires dispositions of interests and land to be in writing. And thirdly, that Murabaha was contrary to Sharia law. Now, it will be obvious to your lordship that none of that was previously part of Deyaar's case in life. In some of their cases, the were expressly or implicitly disavowed by Deyaar's then counsel. Now, we say that quite aside from narrow issues, which would cover, in our submission, all of the points raised, it is abusive to raise the points now. Now, I know your lordship will be very familiar with the doctrine of innocence and innocence, subsequently interpreted by Johnson and Gorwood. A party cannot litigate subsequently issues which could and should have been brought earlier, and that is all the more so after a trial on liability. Now, I'm keen to avoid adding to the plethora of authority the 2 volumes which your lordship has, but there is one case which is very close to this one on the facts, and it's called R&V Decision. And I would like your lordship to have a look at that. It's in the first part of the authority, tab 24. And it's a judgment of Mrs. Justice Gloucester. I'll just tell you a little about the facts because they were quite complicated. It was in the reinsurance arena, so it's not inherently interesting. But the parties entered into 2 binding authorities authorising...
Forgive me, just sorry. Which provider?
Tab 24.
I've got him.
So I'll just tell you all the facts. The parties entered into 2 binding authorities authorising the first defendant to write reinsurance contracts on behalf of the claimant.
Sorry, if it's not in the first volume.
Right. It seems that every case I appear in, the judge has a different bundle to mark.
I've got it now. I've got 4 bundles of authority.
Okay.
Seems appropriate enough.
More than enough.
Yes.
Now, individuals within the claimant and the first defendant had then agreed 2 side agreements which purported to grant the first defendant 40% of all premium in exchange for an interest in an insurance brokerage associated with the defendant, which had no value. Now, in this case, as in the present case, at the liability trial, Mr. Justice Moorfield found that the side agreements were unauthorised and not binding on the claimant. The claimant was entitled to terminate the binders and to recover damages for conspiracy. Now, following judgment, that's when the case bore a striking resemblance to this one. New lawyers were appointed by the first defendant and new points were taken. And a preliminary hearing was listed to decide which, if any, of the defendants' points on quantum would be permitted to proceed. The defendants resisted unsuccessfully any substantive issues being decided. Now, at the hearing, the first defendant alleged that the claimant had ratified the binders and the side agreements, and your lordship will see that in paragraph 19. Yes, if your lordship just reads that to yourself, the only point is that there was a new allegation of ratification.
Yeah.
So essentially what happened is the first defendant wanted to deploy this to argue that any loss the claimant had suffered was caused by ratification, not by the conspiracy. Or alternatively, they wanted to argue that the claimant had failed in establishing its loss, which would have been the difference between a 40% reduction in the cost to the claimant of obtaining the reinsurance services provided by the first defendant. Now, Mrs. Justice Gloucester, unsurprisingly, decided that the first of the arguments was precluded by issue estoppel, and that it would be an abuse to raise the rest. And if your lordship goes on to paragraph 32, it's actually probably best to start at 31. In my judgment, having carefully considered the materials to which I was referred, including relevant passages from various statements of the case and the precise way in which risk conducted its defence at trial, I consider it would be an abusive process for risk now to seek to argue a
Yeah.
And if your lordship goes on to 35, there's quite a long paragraph dealing with the particular facts of the case. But what, and this is Justice Scotti says, I reject Mr. Page's submission that the judge treated the addenda as part of the same transaction or contract as the binders and the passages in the judgment upon which Mr. Page relied. Likewise, I reject Mr. Page's submission that the judge expressly found there had been ratification of the addenda. Neither of these two issues needed to be addressed by the judge in the light of Mr. Schaff's concessions to the agreed position as between the parties at trial. Namely, it didn't matter whether or not the addenda was separate or severable from the binders and were made without authority and therefore not contractually enforceable by this. Since even in the event the addenda had been ratified and were not separate or severable, the full amount of the 40% deduction would be recoverable as damages for conspiracy. No reservation, either express or implied, was made by Mr. Schaff at that time to the effect that R&B would have to prove the actual amount of its loss because of ratification of the addenda. In my judgment, at that point where indeed being reserved for determination of quantity, it should have been expressly and unambiguously reserved. Now here, none of the points which are now relied on by Deyaar were expressly and unambiguously reserved. Quite the opposite. The next part of the paragraph is particularly important. That was because in the circumstances of this case, it was clearly the function of the trial judge at the liability hearing to determine all necessary factual matters so as to establish the parties' rights and obligations, so that the issue of the claimant's remedies and the quantum of its claim could be decided at a later date upon the basis of the judge's findings at trial, without relitigating the issues ventilated at the trial. A trial now before me of issues A, 1, 2 and 4 would in reality amount to a relitigation of issues that were before the judge at the liability hearing and which counsel for both parties agreed did not arise for determination in the event of a dishonest price. In my view, it would be abusive in the extreme if new counsel for risk were entitled to run such arguments at this stage, given the basis upon which the litigation is fought before Mr. Justice Morgan. It follows I also reject Mr. Page's remaining submissions as identified above. Before I leave the case, I should just show you also paragraph 27. Where judge says, at that stage, the only claim for damages by R&B was in respect of the 40% deduction. In my view, it is unlikely in the extreme that the judge could have come to the firm conclusion that R&B is entitled to recover damages for conspiracy if there was any question remaining in play between the parties that ratification of the addenda could subsequently be raised, notwithstanding the dishonesty finding. It supports an argument by this that no loss whatsoever had been caused by the dishonest conspiracy, but only the ratification itself. If that was an argument that was going to be run by risk, then in my judgment that was an argument that had to be run at the liability trial because it was germane to the issue of liability. Now, there's a difference. Mr. Page for risk counsel, its damage is only caused by the deliberate choice of R&B to ratify the agency contract and not by the dishonest conduct of the two individuals identified, then one of the necessary elements of the tort of conspiracy, namely damage cannot be made out. Accordingly, in my judgment, it would not only be an abusive process for risk now to run that causation argument, but it's also precluded from doing so on the grounds of issue itself by the judgment of Justice Morgan, who clearly concluded that R&B was entitled to damages for fraudulent conspiracy in respect of the 40% deduction. So, my lord, the reason I show your lordship that is because in my submission it's very similar to the position which has now arisen in this case. Although I would say the position in this case is even more extreme. Now, your lordship may not remember, but I do want to show your lordship the original case management order in February 2013, which is, I hope is in your lordship's first one, A2. Page 290. This
Divide at A2.
Yes, A2. It's the
Is
last.
that I have is my judgment. No, wait a minute. No, it's a judgment of.
The last 2 pages of A2.
Oh yes, I've got it.
Case management
So
order.
on Chadwick's
Yes.
case manager order of
Yeah.
Yeah, whatever.
If you go to paragraph 14 of 290,
Thank you. Yes.
the Lord will see the trial should discern all of the issues, say that where the assessment of the amount of an award of damages will require expertise, that assessment will be reserved for a later hearing, with direction from the trial judge to enable it to be undertaken, should those claims succeed. So your Lordship sees that order contemplated a quantum hearing on quantification, assessment of amount. And damages were excluded because if it came to quantifying Taaleem's loss, it might be necessary to value the property, although that step might not be necessary, and that's why it was passed. Now, at trial, I don't know if your Lordship remembers, your Lordship raised the issue, and I'll show you, I don't think that's on you on this, unless you've been given.
Thank you. Now, is there somewhere convenient
Yes,
we
if you
might
go
put this?
to the back of, I hope bundle 2, there should be a tab with the letter T on it.
Yeah.
And these pages should go in at the back.
So this is T4, is it? Yeah.
Yes.
Yeah, it is. Yeah.
And if your Lordship to go first of all to day 6,
This is J6, is it?
yes, page 63 first.
Sorry, just let me catch up with my notes. Yes.
And if your Lordship goes to line 15, this is my closing, and I say, like the consequences we've dealt with in writing. And then your Lordship says, I was going to ask about consequences, and maybe I need some what I call joint help here. There are three in a sense, essential outcomes. One, there was an agreement, and it wasn't set aside, or it is not to be set aside. Two, there is an agreement, there was an agreement, and it is to be set aside. Or three, there was no agreement. Now your Lordship might see that actually mirrors what we said with the essential issues, which I said were the essential issues. And I say yes. And your Lordship says, I think Mr. Shea is very helpful, slightly shorter scale of argument, sought to give you some help on those matters in regard to the money side. I'm not clear at the moment whether there is an issue between the parties as to what the financial outcome would be in regard to each of these three possible alternatives. My impression is that there isn't, and in the hopeful expectation there isn't, I would be very grateful if the parties would provide me with the answer to all three variable positions. I say yes. Does that make sense? I don't know. There is no need to grapple with it now. I'd like to grapple with it before we depart at the end of the day, and maybe we get a more coherent position out between the parties on this topic. As I say, as presently advised, because I haven't really looked at the money side of it with KRH, perhaps I should, there isn't much of a dispute about what the outcomes would be on certain conclusions on the principal issues. If there isn't, I'd like to know what the answer is. And then I say that is the difficulty, because there are in theory a number of permutations once you make the primary findings on liability. One thing I was going to suggest, any difficulties or wrinkles only really arise if your Lordship goes down, one could say, not an unusual route, but doesn't go down and make a finding on. And he also says, I'm not making any promises, it may be in due course that the right way is to let the parties see what I've said and then either agree with the outcome is, or write to me and explain the disputes. Quite. I was going to suggest that, because actually I don't think there will be much of a dispute if, for example, your Lordship finds there was a contract for transfer or that there was a contract to transfer. There might be issues if there was no contract at all, because that could potentially get quite complicated. That's where I think issues arise. If your Lordship goes down the option route, and purpose of the trial was wider even than the one that Mrs. Justice Gloucester was faced with. This trial was intended to deal with everything except the quantification of damages. And we do submit that the points now being made actually go to liability, and not just to quantification. They go to the parties' rights and obligations. So we do submit that their new arguments cannot now be raised, and Deyaar clearly ran its case on the footing that if it failed on its two arguments, it would be liable. When I say its two arguments, there was no binding agreement if there was actually set aside the breach of fiduciary duty. And I would just like to show you another extract, another extract from the transcript, which is day one. But I can't give you a page other than in the transcript itself. Day one, page 135.
Just
the front of the T-tab.
Day one, page
Page 135.
135.
135,
Yeah.
you'll see, if you just look over to 131 on the far left-hand side, you'll see it's Mr. Knowles who's speaking at this point. And he's speaking for several pages. And 135 at the very bottom of 925, he says that's all in relation to the question, was there a binding legal agreement or not between the parties? If there was an agreement, then very briefly, because I know your lordship and my learned friends in fact have the essence of this, it comes down to this. First, when such a question arises for decision, no legal system can tolerate a regime for corporate persons without recognising responsibility on the natural persons who act as the leadership of the corporate person. And that's what I say is the we refer to broadly as the fiduciary duty form, but in the way in which it was put by Mr. Knowles. But what is very clear is Mr. Knowles says it comes down to this. In other words, that is the essence of their defence. Now, all of Deyaar's new points offend against that. So they cannot raise now issues of whether relevant consents were given or were in the correct form, whether formalities should have been complied with, and if it is raised, whether Deyaar agreed at all to a deal incorporating to Leeds obligations to national bonds. And we even made that point in our closing. If your lordship would take up 104, page 227. Paragraph 20. Nor is it,
Yeah.
paragraph 20, nor is it alleged that the transaction was not concluded as a result of I do just want to say a few words about specific performance, because we do submit that Deyaar's arguments on specific performance are particularly egregious. Deyaar now say that it's entitled to argue that the contract was incapable of performance because the underlying transaction was varied. And worse still, they say we're not entitled to respond to the obvious incorrect position that the agreement was terminated. Their other points are all about formalities and Sharia law. Now, your Lordship will recall that Sharia law featured in Deyaar's expert evidence. This prompted the complaint that it was irrelevant to the pleaded issues, and Deyaar expressly disavowed it. And I'll just quickly show your Lordship where that is. Again, it's in the transcript section of Volume 2. Day 1, page 138. Where Mr. Knowles, at line 14, very helpfully says, in my submission I will not be saying that any defect in relation to the Murabaha is decisive of an issue in the present case. I note that very responsibly in my submission, the expert for Deyaar in particular has drawn attention to a number of defects, and that's perfectly correct to do so. Indeed, a number of other points could be made as well, but they do not matter for the purpose of this trial. I hope that it's helpful for me to say that as well. So he made that position, making that position very clear, and as a result, the other experts gave no evidence on the issue, and it didn't feature any more evidence. And now Deyaar seek to rely on its expert evidence as if it were unchallenged, and we see that's plainly abusive. I should mention one case that we received this morning, adding to the bundles, which is called Graham and British Gas, and obviously we'll have to hear what my own friend has to say about it. But when your Lordship is showing it, I would just point out that it deals with a quite different situation to this case. In that case, one party was seeking to raise points that it had said previously, one way or another, through counsel, that it wouldn't raise. But those statements had been made at a directions hearing and in correspondence prior to trial. And the judge who dealt with the application dealt with it on the basis that the defendant was seeking to withdraw an admission and amend its case before trial. And therefore no question of issue of stopping arose, and there was no question that what was happening in that case was an abuse. In this case, the case has been tried. After judgment and a failed appeal, Deyaar now seeks to introduce new points. And we submit that there's no way that Deyaar can go behind the findings made in your Lordship judgments, and everything that had a bearing on liability should have been raised before. Finally, there are a whole load of pleading points which your Lordship may have seen from the my learned friend Skeleton. And if I may, I'll deal with this quite quickly and just tell your Lordship what the pleading says and what our position is in relation, rather than taking your Lordship through all of the pleading points. As to the transfer of the interest, Deyaar says in its Skeleton, paragraph 4.6.1, it was no part of Taaleem's pleaded case that it had assigned its equitable interest under the express trust of Sky Gardens to Deyaar on the 4th of December 2008. And as to the transfer of the obligations to national bonds, Deyaar says that Taaleem did not plead that it had delegated its obligations to Deyaar. So in other words, what they're saying is that we hadn't pleaded the fundamental allegations. And that may come as a surprise to your Lordship. It certainly comes as a surprise to us, because we had understood that was what the whole trial was about. But I'll just tell you what the pleadings do say, and you'll find them, and I won't turn them up now. They're in A1, page 7, paragraph 25, in the particulars of claim. We say, thus, by an agreed process of novation arranged by NBC, Deyaar acquired the interest in the property and became liable to NBC for the two payments of 81 million dirham. At that stage, it was unclear exactly what NBC's demand included, but throughout the plea, it's quite clear that Taaleem's case was that Deyaar had acquired Taaleem's also said in paragraph 3, which is A1, page 144, Taaleem transferred its interest in the property to Deyaar and/or Taaleem agreed to transfer that interest. In exchange, Taaleem transferred to Deyaar any and all obligations towards NBC and Deyaar, and Deyaar agreed to assume all such liabilities, and Deyaar paid to Taaleem and/or agreed to pay a premium in the sum of 72 million. Now, my Lord, the short point is, a pleading point is taken, and it is wrong. We have made that clear. I've told your Lordship what the pleadings say. I don't know whether it's going to be advanced today, but it's not pleading. But if it is, we'll deal with it in the reply. They also say that specific performance was not pleaded, but we submit that clearly was pleaded in the reply at paragraph 7. It was in the list of issues. It was in our written opening, and it was in our oral opening. Again, nothing was pleaded in response to our allegations, and no objection was taken to it being pleaded in the reply, and it wasn't dealt with in the rejoinder. So the short point, my Lord, is that pleading points are taken, but they're simply wrong. I don't know if they're going to be maintained. So we say that is the end of it. Your Lordship has decided that there has been a transfer, at least of the obligations to national bonds, and also of the interest to. None of Deyaar's points open to it, either because their issue is stopped, or because it would be an abusive process on Henderson and Henderson's principles. If there has not yet been a transfer of any element of the deal, then there should be specific performance. And once you take away the points Deyaar has precluded from running, we submit there is no defence, and your Lordship can do the specific performance. Now, my Lord, we've set out in writing in some detail why Deyaar's new points are all wrong. On a spectrum, some are extremely wrong, others are simply wrong. But if I may, I deal with any of those that your Lordship is in any way concerned with in reply. We put it all in writing. I don't need to deal with that. Your Lordship has seen the order we seek. I might just show your Lordship. It's in volume 4, page 328. Now, this is in the index. This is actually listed as NBC's order, but in fact, it's a joint draft of NBC and Taaleem. And I'll just tell your Lordship what's in issue as between Taaleem and NBC. Paragraph 1 is agreed as between Taaleem and NBC, and that is the declarations that on the 4th of December the claimant and the second defendant concluded an agreement pursuant to which the claimant's interest in the units in Sky Gardens was transferred to the second defendant, and the claimant's obligation to repay the first defendant the principal monies advanced to finance the purchase of the interest, as well as the Murabaha profit of late payment charges, were transferred to the second defendant. So that we submit is a declaration which is entirely consistent with your Lordship's judgment, as is paragraph 2. By virtue of the agreement, the claimant ceased to be the owner of the interest on the 4th of December 2008. The second defendant became the owner of the interest on the 4th of December 2008. And C, which is a matter in dispute as between NBC and Taaleem, the claimant is not liable to the first defendant, that is national bonds, any finance provided by the first defendant for the purchase of the interest, whether under the terms of a Murabaha agreement entered into between the claimant and the first defendant and dated the 6th of July 2008 or 2. And I can't speak for Mrs. Cannell, but the reason for that is because of the point which is now taken by Deyaar, in case your Lordship is attracted to the suggestion that we are obliged to pay, notwithstanding your Lordship's judgment. So they reserve their position in relation to that. Then
can helpfully adopt much of what Mr. Flynn
Yeah.
has said, and certainly in relation to the SPA issues, NBC is happy to adopt the same position as Taaleem. If I may, my Lord, I would just like to take you to a few documents in relation to the specific issue of whether the position between NBC and Deyaar. I entirely adopt my learned friend's submission that the consequence of the judgment is that Deyaar is that the obligation, that Taaleem's obligation to repay NBC has transferred to Deyaar. And I'd just like to take your lordship to the specific issues which you were asked to decide. So if we go to bundle 4, tab 6. It's page 289.
Thank you.
This is the agreed list of issues which was sent to your lordship on the 19th of December last year, so after the trial has finished.
Yes.
And your lordship will see at issue 1 there on page 289, did Deyaar and Taaleem enter into a legally binding agreement under which Deyaar assumed or agreed to acquire Taaleem's rights and obligations in respect of Sky Gardens, including Taaleem's obligation to repay NBC in respect of the financing it provided to Taaleem to purchase the interest in Sky Gardens. And then, if we move over the page onto page 290, you then see issues 5 and 6 relate to the position between Deyaar and NBC. And issue 5 is, if the answer to issue 1 is yes, i.e. there has been a transfer of Taaleem's rights and obligations in respect to Sky Gardens, including Taaleem's obligation to repay NBC, was there a novation or an assignment to Deyaar of Taaleem's obligation to repay NBC, and in either case did that enable NBC to sue Deyaar? Now, we can then go to the judgment page, which starts at page 292, and we can go to paragraph 1, which is at page 293. Your lordship gives a brief description of these proceedings, and the last sentence of paragraph 1 states that the dispute centres on whether the claimant, Taaleem, or the second defendant is liable to repay that sum, and it's talking about a sum in excess of 200 million dirhams, which the first defendant, NBC, has advanced. So your lordship has well in mind what the key issue in these proceedings is. And if we then go forward to paragraph 76 of the judgment, which is at page 306, you'll see that your lordship sets out what's described as the threshold issue, and if you could have you'll note, my lord, that there's words in parentheses. So your lordship talks about the threshold issue being whether negotiations between Taaleem and Deyaar led to a legally binding agreement under which Deyaar assumed or agreed to acquire such rights and obligations. And then we have words in parentheses, including Taaleem's obligation to repay NBC in respect of the finding that it provided to Taaleem to purchase its interest in Sky Gardens. So those words almost exactly mirror the words in agreed issue 1, which you were asked to decide. So your lordship had well in mind what you were being asked to decide, and my learned friend's already taken you to your findings, and at paragraph 89, your lordship finds that in reality, referring to the payments of 114 million dirham, your lordship refers to Deyaar having recognised its responsibility in lieu of Taaleem to make the payments. And of course that 114 million includes payments to NBC of it was of approximately 50 million dirham. And then to paragraph 94, Your Lordship then says, I conclude that Taaleem and MBC have made out their case. The contract of sale or at least transfer was concluded in December 2008. So, my Lord, with in NBC submission, the clear effect of your judgment is that you found that there's been a transfer of the repayment obligation towards NBC, and that transfer is from Taaleem to Deyaar. Now, I took you to issue 5, which was the innovation assignment issue, and the relevance of that issue for to where we are now is that if there was innovation, then Taaleem is no longer liable and Deyaar became liable. If there was an assignment, then it's by way of delegation and Taaleem remains liable in addition to Deyaar. So there's no dispute about whether Deyaar is liable, it's just whether Taaleem remains liable as well. In NBC primary submission is that the effect of paragraph 89 is that Your Lordship has found that there has been innovation and that Deyaar has been substituted in place of Taaleem as the debtor vis-a-vis NBC. And that's our primary position. But mindful of the case that Deyaar is now running, we hadn't wanted to concede that position, and that does need to be decided. So whether there was an assignment or innovation, we would say that's the only issue of the list of issues that Your Lordship didn't decide. But that can be determined, and our position is that there was innovation. And so, if Your Lordship accepts that, then I can agree to the 2 paragraphs of the draft order my learned friend has taken me to, which is paragraph 2C and paragraph 5, which dismisses our counterclaim against.
Let me just remind myself of that. If
yes, so the order is
just remind the pages. Very good.
the draft order states it starts at page 328. So it's page 329.
Yes.
So if Your Lordship finds there was innovation, then we're content.
You're happy with
then we're happy with 2C.
2C.
Yes, and 5 isn't queried in this version, but in the version we sent with our skeleton argument, we did put square brackets around that as well. But if there's innovation,
Say again, yeah.
we're content with paragraph 5 as well.
Understood.
And as you said, our primary submission is that finding at paragraph 89 that payment was made that Deyaar recognised its responsibilities to make payments in lieu of Taaleem. That shows that Deyaar is meant to be taking Taaleem's place, not just joining it. That is consistent with innovation. And my Lord, this Your Lordship would have gathered that there was an unsuccessful attempt to appeal against Your Lordship's judgment, and one of the grounds of appeal was that Your Lordship hadn't decided issues 5 and 6 relating to the position between Deyaar and NBC. Those are at page 317 in bundle 4. It's paragraph 15. It says the learned judge erred in failing to consider issues 5 and 6 of the agreed list of issues. If we then go to the judgment of Justice Giles in dismissing Deyaar's application for permission to appeal. And if we go to page 327 of that bundle, and it's at paragraph 52. And I think if you just go to the previous page, 326, you'll see here that Justice Giles sets out to issue ground 15 and issues 5 and 6. And then paragraph 52 said trial judge's conclusion that a contract of sale or at least transfer was concluded in December 2008, and that there was a concluded agreement for transfer of Taaleem's interest in Sky Gardens to Deyaar on the 4th of December 2008, does not spell out the position as between Deyaar and NBC. Then says there are a number of references and the reasons to that position. And he then refers, he says, first to various documents, and then says an addendum to the tripartite agreement was prepared, apparently involving NBC's finance. Nonetheless, the position as between Deyaar and NBC is not made clear in the reasons, and to that extent, I accept that the ground of is a valid complaint. So, but he then finds that the consequence of that is not that leave to appeal is granted, just that we have to come back before your lordship. And but that it's important to understand that Justice Giles is saying that the extent to which he considers there's a valid complaint is just that the position is not spelled out, and we submit that that's just the assignment innovation issue. So, my lord, like my learned friend Mr. Flynn, NBC's position is that the clear effect of the judgment is that Deyaar is liable to repay NBC. Deyaar has raised various new points. Deyaar has raised various new points and reasons why it says we're not entitled to the draft order. My lord, in my submission, as my learned friend has said, Deyaar, there should be an issue of estoppel or Henderson abuse. That it can't be open to a party to lose in the judgment and then raise a whole raft of new points when the order is drawn up, which it should have raised earlier. And we've had no formal applications for Deyaar to amend its case. They've cited various cases which show why judgment can be reconsidered or why new points can be raised, but they involve making an application for permission to amend the case. We had no such application. We have no knowledge of when these points were thought of, why they weren't run before, and it simply isn't open to them to come along today and take these points. I would so if I could also just like to another in some of those cases where judgments are being reconsidered. One of them is a decision of the Supreme Court, in which considered the barrel jurisdiction to reconsider a judgment, and held that exceptional circumstances are not always are not required. That the court must do justice in the case. But it's important to note in those decisions, which the majority of them seem to relate to childcare proceedings and preliminary fact-finding hearings, that the actual hearings at issue were not meant to be final hearings. The trial that took place last year was obviously intended to be final hearing on in this matter, certainly on liability, with a very limited but with quantum hived off perhaps to a later date if necessary, as my learned friend has just shown you. But it was intended to be his final hearing, and like my learned friend it's somewhat surprising to find ourselves here and to deal with all these points that should have been run earlier. Another point which my learned friend, Mr. Leach, in Skeleton and in the note, complains that, again, takes pleading points with NBC and says that it was not clear that NBC was relying on innovation. It says the primary case was assignment and it didn't plead innovation. At the pleading stage, NBC's position was it wasn't really able to plead a positive case on the issue of innovation because it wasn't the party involved in all these fully involved in all these matters, and it wasn't fully aware of many matters. It wasn't in possession of various documents, but it was always clear that NBC's case was always that Deyaar had agreed to assume Taaleem's obligations towards NBC. And my learned friend's specific point is that NBC never at any point said that there was an agreement between NBC and Deyaar, which would be necessary for there to be innovation. An assignment is obviously that there isn't necessarily that contractual relationship between NBC and Deyaar, whereas with innovation you have a substituted contract. That's not correct. NBC's case, as set out in its opening, was that there was a contract between NBC and Deyaar, and I can take you to the reference. That's bundle 4, page 147.
147.
Yes, page 147 of the bundle. It's page 94 of the skeleton, but page 147 of bundle 4.
Yeah.
And you'll see there the heading, Roman numeral, small Roman numeral 4. Deyaar agreed with NBC that it would repay the amounts paid on behalf of Taaleem. So Deyaar always knew the case it had to meet. It always knew that innovation was being alleged, and as my learned friend says, it was always part and parcel of the deal that Deyaar would assume Taaleem's obligations towards NBC. It was part of the price of the deal. In relation to the Mirabaha point, if there's to make another point that's taken against NBC is that there couldn't have been an agreement. There can't be that direct contractual relationship between NBC and Deyaar because at the end of 2008 and into 2009. NBC and Deyaar were still negotiating over the form of the documentation required for the agreement, and this point was made. It's made by Deyaar in closing paragraphs 67 and 82. Paragraphs 67 to 82 of its closing, and that's pages 276 to 278 of bundle 4. Page 276.
Yeah. This is the NBC closing.
No, this is Deyaar's closing.
No, Deyaar closing, sorry.
the heading there is paragraph 67,
Yeah.
and you'll see the heading there. As regards NBC, there is in any event no binding agreement between Deyaar and NBC. And Deyaar takes this point again in the skeleton. For this hearing, they say there can't have been an agreement between NBC and Deyaar because you're still negotiating the form, or you're still negotiating these agreements. And my lord, so that submission was made to your lordship at the hearing, and that was the main point made by Deyaar against NBC, repeated by my learned friend in skeleton. The answer, my lord, is that, and if I could take you to paragraph 77 of the judgment, your judgments, which is at page 300. If we go to page 306. You see it, paragraph 77, your lordship sets out various the relevant legal principles which were summarised by my learned friends Mr. Flynn and Mr. Montague-Smith, and you gratefully adopted a revised version. There were no issues taken by NBC or Deyaar with this summary. And then over the page at 307, there's principle 4. The fact that parties continue to negotiate after a contract is concluded does not alter the binding nature of that agreement. And that's a reference to the RTS flexible systems case. The parties may intend to go on to agree the implementation of the contract or to record the terms of what has been agreed. And then there's a quote from Mr. Justice Andrew Smith in the Bear Stearns case. The proper approach is, I think, to ask how a reasonable man versed in the business would have understood the exchange between the parties, nor is there any legal reason parties should not conclude a contract while intending later to reduce their contract to writing and expecting that the written document should contain a more detailed definition of the parties' commitment than had previously been agreed. And, my lord, that's what we would submit happened there. It was always part and parcel of the deal that Deyaar would assume Taaleem's obligations to NBC, and that was factored in as part of the price. Deyaar went ahead with the deal in December, as we know, by paying the premium, and at that point there's an agreement there that incorporates that agreement between NBC and Deyaar, and then of course Deyaar goes ahead and makes repayments to NBC in 2009. And you'll see at Principle 5, your lordship also says the fact that payment is made is a very relevant factor in deciding whether a binding contract is made. So, my lord, I submit that the submission was already made to your lordship that there was no binding agreement between NBC and Deyaar. Your lordship had the relevant legal principles in mind, and was fully entitled to conclude that there was an novation which incorporates the obligations to NBC reached in December 2008. In relation to assignment, of course, the point made by my learned friend makes various objections to assignment, none of which were taken at the time, such as that assignment was forbidden under the Mirabajo agreement. There was a clause prohibiting assignment. My lord, our response to that is that that's not a point that Deyaar can run now. It didn't run it at the time. In any event, it's a bad point. That clause is there for the benefit of NBC, not for Deyaar. Perfectly open to NBC to waive that point. And, given NBC's conduct throughout the end of 2008, it's ludicrous to consider that it didn't waive any right to insist on the prohibition of assignment. relation to the Mirabaha point, my lord, I adopt what my learned friend said. This point was expressly abandoned. As Mr. Knowles conceded that that any alleged defects about the Mirabaha agreement didn't make any difference to the issues in the case. In his skeleton, my learned friend seemed to suggest that it was perfectly proper or correct, I think is the terminology of Mr. Knowles, to make that concession at that stage. The implication being that Deyaar still gets to raise the point now that Taaleem's making a case on specific performance. With respect, he doesn't get to run that point now. If it's going to be run at all, it should have been done in a proper way, which wouldn't have been just raising it in the way it was done in the expert reports, but it should at least have been run before trial. NBC has always made a claim against Deyaar under the Mirabaha agreement, a claim in debt. If Deyaar was going to suggest that the Mirabaha was somehow void or that debt claim shouldn't be granted because of illegality, then it should have made that case. I'll perhaps deal more with the merits of the Mirabaha point in reply to my learned friend, but it's not the case that Deyaar's evidence and its case on the Mirabaha is unchallenged. Deyaar says that it's telling that NBC didn't suggest that the Mirabaha is valid. That's not been NBC's position. It just didn't deal with the point that was raised late and inappropriately. Unless there's anything else I can help your lordship with now, then.
No, thank you very much. Yes,
My Lord, we fully accept that we are the new players in this particular exercise, but the starting point for us, as for your lordship, has got to be the judgment itself. And in our order, my lord, which you'll find at page 369, we invite the court to make a declaration in effect in the terms of paragraph 98 of the judgment, which you'll find again, my lord, you've been taken to it already, which is at page 310. So the conclusion that your lordship reached in relation to issue 1, or the threshold issue which was defined earlier in the judgment, is in summary, therefore, the position is in my judgment that, as stated by Mr. Azam, there was a concluded agreement for transfer of Taaleem's interests in Sky Gardens to Deyaar on the 4th of December 2008. And then one has the various individual points that you made, and primarily an amendment to the tripartite agreement to that effect had been prepared. And your lordship, I just want to take you briefly, if I may, just to that document, which you'll find in bundle 3. Bundle 3.1, my lord.
the 3.1.
Effectively, a new core bundle has been created, in which the documents referred to now by the parties have been created. It's in the sort of commercial court fashion, so that the old numbering has been.
Thank you. Yeah.
So just simply to avoid renumbering with the parties.
Yeah.
So if what one finds is that the page reference is E143802, and it's about a half an inch in from the.
Yeah, I've got it.
Your lordship referred earlier in the judgment to a draft of the amendment to the tripartite agreement having been agreed in November, but the actual amendment which was circulated, and one sees this from the immediate preceding 2 pages, or from 3794, this is on the December the 3rd, so this is in effect the draft that was in circulation on the day immediately before the payment is made, finding that your Lordship has made, and you'll see that this agreement is dated the 31st day of August 31st day of August 2008. Then you have the parties: Amlac Finance, DIFC Investment, Taaleem, Deyaar. And then, if I could just go across, I won't trouble you with the recitals, but if you go to paragraph 1, you have the original parties confirm their consent to the sale by Taaleem of the Taaleem share to Deyaar on the terms and conditions set out in this agreement. Original parties hereby acknowledge that Taaleem has complied with, or to the extent necessary, the parties waive the obligations imposed on Taaleem under the terms of clauses 4 and 5 of the tripartite agreement. And in consideration for the payment to Taaleem by Deyaar of the sum of, and that figure obviously was intended to be the 72 million for the premium, in receipt of which Taaleem hereby acknowledged. Taaleem agrees to transfer to Deyaar the Taaleem share, and the original parties and Deyaar agree that all references to the tripartite agreement to Taaleem are hereby replaced with references to Deyaar, and that Deyaar shall henceforth assume in the place of Taaleem all of its rights and obligations under the tripartite agreement. And I'll come to the tripartite agreement in a moment. But we submit that to someone coming to the judgment afresh, and I'll come back to my learned friend's points in relation to the rest of the judgment, the terms of the contract that appear to have been found appear to be reflected in that document. Price and other central terms had been agreed, so that the price of the transfer had been agreed, and in fact it was paid. And then there were the questions about whether there had been approval, which your Lordship has found, and we don't, at least don't now seek to challenge them in any way. And then F, this payment enabled Taaleem to arrange to include the payment in their account subject only to completion of documentation. There were no conditions to the transfer. The transaction was accepted to be irreversible. Now, if one then, so that's what we, in our submission, your Lordship held, that in answer to question 1, or the threshold issue.
So, just to give me 1 moment, I failed to keep a record of that cross-reference to the...
It's E1, my Lord, 3808, 3802, I beg your pardon.
Yeah.
And, my Lord, we're fortified in that conclusion by what the Court of Appeal...
No, I'm so sorry, I'm cross-purpose with you. The draft amendment of the tripartite agreement is E14, yes?
E14 3802.
Thank you so much. Yeah, sorry.
And coming to this afresh, when one then goes to the Court of Appeal's judgment, my Lord, which you'll find on 318, just take you, it's the paragraph my learned friend Mr. Kennell took you to. It's on page 320.
Yeah.
Paragraph 14. The ground which was raised by our predecessors, this ground is that the trial judge failed to identify the terms of the concluded agreement in the skeleton arguments that's asserted. This is because he couldn't do so, and that no terms had been agreed. The ground is not relevantly developed in the skeleton argument. So that was the ground of appeal. And in paragraph 40, the trial judge found that the parties had agreed on the price and other essential terms. While he did not enumerate the terms, the core agreement can be found in his reasons. In particular, he found that the final draft of the amendment to the tripartite agreement was available by 20th November 2008. And that's the amendment we've just been looking at, or the most up-to-date.
I'm sure it's necessarily the final one. Anyway, it's all I said was there was a draft of the amended tripartite agreement.
So, and then in paragraph 50, to the extent that the ground of appeal is that the terms of the agreement could not be found, in my view, it's not reasonably arguable. Any complaint that the trial judge did not find the terms of the concluded agreement is not a matter of appeal. Orders have not yet been made. The trial judge left it to prepare the orders in the light of his judgment, and any debate over what the terms are will arise in settling the orders, if necessary, with application to the trial judge to resolve disagreement. And then moving on to paragraph, if we may, my Lord, to paragraph 52 and 53, perhaps I can take it up at page 49 on 326.
Yeah.
Ground 15. The ground is simply that the trial judge erred in failing to consider issues 5 and 6 of the agreed list of issues. The list of issues was agreed, and your lordship's been taken to that. Issue 1 was whether Deyaar and Taaleem entered into legally binding agreements. And then issues of 5 and 6 were predicated on an affirmative answer to issue 1, and in summary were, and then he sets out issues 5 and 6. At the commencement of his reasons, the trial judge said that the dispute centred on whether Taaleem or Deyaar was liable to repay NBC a sum in excess of AED 200 million advanced by NBC to Taaleem. Thereafter, he referred to the central issue of whether there had come about a concluded agreement by which Taaleem transferred its rights and obligations in respect of Sky Gardens to Deyaar, or alternatively if Deyaar had agreed to purchase its interest in Sky Gardens, and to Taaleem's claim that there had been a novation between NBC and Deyaar. The trial judge's conclusion that a contract of sale or at least transfer was concluded in December 2008, and there was a concluded agreement for transfer of Taaleem's interest in Sky Gardens to Deyaar on 4th December 2008, does not spell out the position as between Deyaar and NBC. Number of references in the reasons to that position. It says, for example, an email from NBC on 20th of October 2008 recording the structure of the transaction deals with Deyaar's acquisition of Taaleem's interest in Sky Gardens, and also its undertaking the financial obligations to NBC. And an addendum to the tripartite agreement was prepared apparently involving NBC's finance. Nonetheless, the position as between Deyaar and NBC is not made clear in the reasons, and to that extent I accept that the ground voices a valid complaint. However, the consequence is not leave to appeal. As with ground 3, Deyaar's obligations towards NBC will be stated in the orders yet to be made. Nothing has been done towards making them. If the parties cannot agree on translating the trial judge's reasons into presumably declarations as to whether Taaleem or Deyaar is liable to repay the AED 200 million to NBC, and otherwise the financial obligations between the parties, the trial judge can be asked to resolve their dispute in settling orders. That is Deyaar's proper avenue, not appeal. And I just, the word I place some emphasis on it is the word whether in line 4. It's whether Taaleem or Deyaar is liable to repay the AED 200 million to NBC, and otherwise the financial obligations between the parties. The trial judge can be asked to resolve their dispute in settling the orders. That is Deyaar's proper avenue, not an appeal. So our submission, my lord, is that we are doing no more than coming back before you to ask you to resolve the first question, namely what were the terms of the contract. And our primary submission would be, as we've said in our skeleton argument, that it was to enter into the amendment to the tripartite agreement. Nothing mentioned in the amendment to the tripartite agreement about financing of NBC and Deyaar's obligations. And then secondly, to ask you to resolve the second question, whether Taaleem or Deyaar is liable to repay the AED 200 million to NBC, and otherwise the financial obligations between the parties. And in that, again, we rely on the absence of that in paragraph 98, and the reasons which we set out in our skeleton argument. Now, the reason that we use the word appropriate is not because we were assuming that findings had been made. We were, in fact, assuming the reverse. As you'll have seen from our order, what we invite you to do is to make an order effectively, or declaration, effectively mirroring paragraph 98 of the judgment. What we ask you to do is to clarify precisely what that means. And if necessary, to make further findings. Now that in our submission is not an abuse process, because that's what the Court of Appeal had invited us to do. Maybe said in answer, well, those issues were at large at trial, and they may or may not implicitly, they may not have been addressed, but that is the situation in which we are placed. And in our submission, that is the correct approach. And we submit that your Lordship was right to limit the finding in paragraph 98 in the way you did. And that's why we've used the word appropriate. We said with respect in our skeleton argument you were right to reach that conclusion. And we give reasons why it was impossible to reach wider conclusions, the conclusions that the other parties invite you to assume. And one can compare the position between our declaration and what we say the limited effect of the finding with is what Taaleem's position is. It says, if one goes to paragraph 11 of their skeleton argument,
Sorry, whose?
paragraph 11 of Taaleem's skeleton argument.
Yeah. On the present one, or?
The present one.
Yeah. Yeah.
And we say in our submission, my Lord, that it's impossible to spell out an actual transfer of those things from paragraph 98 of the judgment. And because it's suggested that it's abusive for us to ask you to clarify the findings that you made in the skeleton arguments of my learned friends, in the way suggested by the Court of Appeal, we did put in our bundle, but didn't cite in our skeleton argument, a number of authorities which we say show that that is the right approach. So I would ask you, if I may, to go first of all to bundle 1, I believe it's in tab 7. I beg your pardon, my Lord, it's tab 26, I beg your pardon, that's the wrong reference. I believe that's probably in bundle 2, but if you'll just give me a moment, because there are now 4 bundles of authorities, and I've got them in 2 separate bundles. But it's tab 26 of the authorities bundles. And I think that is bundle 2, I'm grateful to my learned friends. But if you'll forgive me, my Lord, finding the authorities may just take me a little more time because of the different bundles. So if one goes to tab 26, you'll find the decision. It's right, it's a family case, but I'm going to show you one case which is a commercial case. This is the Court of Appeal. It's actually in the law report, so it's Re-S, and it's the holding that you'll find at H6. Held allowing the application for dismissing the appeal, the judge had come to clear views based on the evidence to which he was entitled to come. The fact that he did not refer to the evidence of the consultant psychologist did not mean that if he failed to take into account or reach conclusions inconsistent with it. If counsel takes the view after the judgment that the judge has not dealt with a material part of the case or the evidence of a particular witness, it's his responsibility to bring that to the judge's attention and ask him to give a supplemental judgment rather than to apply for permission to appeal. And what is said in the headnote is reflected in the judgment itself, which you'll find at page 120 of the bundle, paragraph 22 of the judgment. And I just invite you, if I may, my Lord, just to read paragraphs 22 to 25, or I can read them out, whichever your Lordship.
No, I'll read them. 22 to 25.
Yes, my Lord.
Yeah.
So we, in effect, ask you, my Lord, to make those supplemental findings. Now, we may be disappointed with the
Well,
outcome.
it's slightly surprising to come to that position after you've actually made an application for leave to appeal.
Well, I agree with you, my lord, but we were told that the appropriate course was the one which is identified in the authorities. And it is flagged up in the Court of Appeal's decision. And in a sense, the reason why we have put...
Anyway, all you're, in a sense, emphasising, as far as it goes, is that the judge who dealt with the application for leave to appeal thought there were some matters which either were not spelled out or not sufficiently spelled out. I understand that.
Yes.
Right. But I mean, just looking at this judgment, it suggests that you shouldn't have gone around asking him in the first place.
Well, it may be the right thing.
That's one of them. Now, you want to look at the commercial case, is that right?
Well, I just want to take you, first of all, to the decision, the Supreme Court's decision, to show you that
Right.
before an order is made, the judge does have a wide discretion.
Right.
And I think that is still in Bundle 2, A232.
No, I think that's bundle 3.
Oh, that may be Bundle 3.
What, divider 32?
Divider 32.
Yeah. Good heavens. No, no.
I think it's volume 4, my lord. I'm sorry.
Insufficient for services for the Excalibur Ventures, which occupies it.
Occupies
volume, I think.
the entire volume on itself.
Right. Bundle 4. Divider 32. Okay.
And it's again the holding, you don't need to be...
Yes.
And you can see the power of the judge to reverse his decision at any time before his order was drawn up and perfected by being sealed by the court was not limited to exceptional circumstances, that the overriding objective in the exercise of power is to deal with the case in question justly.
Yeah.
That relevant factors to consider would include, on the one hand, the party having already acted upon the decision to his detriment, and on the other, the existence of a mistake by the court. And you can see what they say. And the reason for showing you this is really to remind you, my lord, if one goes on to page 640 in the judgment,
Yeah.
paragraph 16.
Thank you.
Long been the law that a
Just
judge...
might suggest time to appeal hasn't started to run yet. It's slightly bizarre, this
Well, it
analysis.
is, my lord. I haven't to say, I'm in the lucky position of saying it wasn't my decision to make the application to appeal. All I'm suggesting to you, my lord, is that the right course is now being taken.
Well, all right. Yeah.
So 19, that's there is just
I
jurisdiction.
think the right course was that if there was any doubt in the mind of your clients as to what I had held, the right course was, first of all, to get me to elaborate if necessary, and then invite me to make an order, and then, if so advised, as part of that order, seek leave to appeal.
Yes.
So we seem to have actually gone in reverse order. Right? Never mind, on we go. I don't think I need authority for proposition in paragraph 16. Though it takes quite a bold judge to reverse his decision.
Well, we're not inviting you to reverse your decision, my lord. We're
I
simply...
don't know about that. Maybe that. But obviously to revise it, certainly he can go on revising his judgment until the law reporters are given up, I suppose. Anyway, sorry, I'm interrupting too much. Okay.
Well,
Yes.
in Stewart and Ingle, it's how you exercise that jurisdiction.
Yeah.
And it's the dissenting judgment of Lord Justice Clark. He said,
Oh,
Lord
that's
Justice...
quite interesting. Yeah. He disagreed, did he?
He did, my lord.
What was his view?
The important thing about Riel is that they upheld to summarise the position, the barrel jurisdiction, which your lordship has been entirely familiar with, that was that you require exceptional circumstances before the judge can revise his judgment, was in a sense a rule. So that's one, could be paragraph 27. That's
So where are you now?
paragraph 27.
Thank you. Yes, well, I mean, I suspect that we're in the world of the clear disparity between the position before an order is made and the ability to advise a judge to revise his decision and to revise his judgment, and the position once a judgment and an order has been given, then going to the Court of Appeal and saying you would like to open up a further issue in the case which hadn't been pleaded or something like that. A fortiori, once the appeal has been decided, going back to the Court of Appeal and inviting them to reopen the appeal. But it's sufficient for your purposes to say, well, it certainly would have been perfectly legitimate to invite me to enlarge upon the reasons I've given.
Indeed, my lord, and to we would submit.
I mean, whether I would have responded is another matter, but there was nothing perfectly proper request.
Indeed, my lord, and it's the submission that being asking you to do that, particularly in the light of paragraph 98. As I said, we may or may not like the answer, but in our submission, it's not an abuse to ask you to do it. That's really that's really our basic submission. And it's clear if one looks at the other parties' skeleton arguments that they accept that, or at least in the case of NBC, who's the party that matters, that they accept that you didn't make an explicit finding that we assume the obligation. And if one goes to paragraph 20 of NBC's skeleton argument,
Yeah.
They address the points there that my learned friend Mr. Kennell made on his feet a few moments ago. Shifted his position slightly now, and he says Deyaar alleged a failure to determine issues 5 and 6 as part of its unsuccessful appeal. And they quote from paragraph 52. Yeah. Justice Giles did not agree with Deyaar, save to the extent that he indicated that the judgment does not spell out the NBC Deyaar position. That is correct insofar as the judgment does not contain a sentence which states expressly that Deyaar is liable to repay NBC. Well, it is the absence of those words, my lord, which is particularly important. They may have been, for all I know, you may have considered that issue and decided that it was inappropriate to make that finding. And I use that word because that's the best way to describe it. It may have been, the wording may have been chosen with some care, and we submit that in this case it was impossible, in fact, to make a finding. And there are other alternatives. You use the words, my lord, concluded agreement for transfer of Taaleem's interest in Sky Gardens to Deyaar. Now, what's now being said is that is a finding that there was a novation on that date. Now, the critical issue that I just ask you to consider, my lord, is that throughout the arguments, at least in relation to both in the opening and closing submissions, and I wasn't obviously present at the trial itself, but there does seem to be a basic failure to distinguish between two contracts. What's taking place on the 4th of December, if a novation takes place, is a novation of two contracts. The first contract is the tripartite agreement, and this is really the fundamental basis of our submissions in section 4 of our skeleton argument. But there are two contracts here. There's a contract between DIFCI, AMLAC, Finance and Taaleem, And then there is a quite separate contract, a Murabaha agreement, between Taaleem and Deyaar. And a novation of one does not necessarily amount to a novation of both. One has to prove a novation of each contract or an assignment. And those are very distinct legal concepts. And I can, again, it's helpful, my learned friend Mr. Kennell's submissions. If one goes to paragraph 35, of his skeleton argument on page 9, he cites a decision of your own, my lord. I don't know how one pronounces that. Taiki, number 2. Relevant state, Mr. Justice David Steele stated the relevant principles regarding novation. As might be expected, there is no dispute as to the relevant legal principles. They can be summarised as follows. Novation involves the creation of a new contract where an existing party is replaced by a new party. Thus, novation requires the consent of all parties, including in particular the party which is thereby accepting a new person as his debtor or as his counterpart under an executory contract. Consent may be apparent from express words or inferred from conduct. The consent must be clearly established on the evidence as being only consistent with the intent of achieving a novation. So it's not simply finding. Novation was clearly pleaded by my learned friend, Mr. Flynn's clients, but it's not simply the finding of the existence of a contract. It's the finding that the consent must be clearly established on the evidence as being only consistent with the intent of achieving a novation. Now, so that's novation. And then if one goes forward again to paragraph following page, paragraph 37.
My lord, it might, I hesitate to interrupt, but it might be helpful to go to 36 as well, just given that that clarifies the particular point that's just been clarified.
So I couldn't hear what you said.
He's asking me to refer you, my lord, to paragraph 36, which I'm happy to do.
Yeah, thank you.
And then in 37, again, my learned friend cites from Argo Fund v. S.R. Steele, and it's really the part of the sentence which is in bold and italics in paragraph 64. The legal arrangements involved in a novation and an assignment are so different that an intention to undertake a novation is incompatible with a simultaneous intention to make an assignment of rights. And one, take a very simple example, it's clear that what NBC thought they were consenting to much later in April was an assignment. And I'll take you to that document in a moment or two. And the initial point we really make in relation to the finding, my lord, of paragraph 98 is that there are quite a large number of possibilities in relation to 98, the outcome in relation to 98. The first is just take the words as they stand, which is in our submission the right conclusion, which is that there was a contract for the transfer of the interest, a concluded agreement for the transfer of Taaleem's interests in Sky Gardens on Deyaar. That's a contract to transfer the interest, and for the reasons that we give, and I'll come to, it couldn't have been anything else. There are two different contracts already in existence at that date. The second contract is a contract between NBC and Taaleem, quite different parties. No mention in paragraph 98 of those two parties or that contract. The interest in Sky Gardens is an interest under a different contract. So it doesn't necessarily follow, we say, simply as a matter of language, doesn't necessarily carry with it, we say in paragraph 98, that it must have involved a transfer of the obligations. May have possibly have involved a contract to accept those obligations. May have been an assignment, it may have been a novation. And it's likewise in relation to the tripartite agreement. And that is really the reason why we're not seeking to take new points. We're simply saying that the finding in our Osculus argument, we're doing what the Court of Appeal has asked us to do. We ask you to clarify the terms of the contract that was made on the 4th of December 2008, and we make the point that there are two contracts here, the tripartite agreement and the Murabahar agreement. And in relation to the tripartite agreement, it's impossible to see how there could have been a novation of that contract on the 4th of December 2008 for the very simple reason that there was no consent by the other parties to it.
Well, as Mr. Flynn says, that was a point that was never made. The issue that was before me is, I think, relatively accurately described in paragraph 76. The whole of the discussion as to whether the parties had entered into a concluded agreement was not in any sense circumscribed by any discussion about the need, for instance, for consent of other parties interested in the property. Now, you may be right, I don't know. But there is a limit to what courts can do to foreshadow points that might have been made. I think you can take it from me, it was not a point that was made.
Well, I'm perfectly happy to take it from you, my Lord, if it was not a point that was made. And it might be, my Lord, that if you had found, as a matter of fact, that there was a novation of that contract on the 4th of December 2008, it would be impossible for me to advance this point. But all I'm saying is that there is a reason why there was simply a concluded agreement for the transfer of Taaleem's interest and not an actual transfer. In fact, there are two reasons. And it is not, in my submission, it's not abusive for me to make that point now and say, my Lord, you should clarify your judgment and make it clear that that's exactly what the contractual position was. And part of the trouble here, in my submission, is that my learned friends didn't make it clear, didn't separate out the two contracts, and indeed they haven't done this afternoon. There was an interest under one contract and a set of obligations under another. And I'm going to come to another point, my Lord, in relation to the obligations, because again, in my submission, it's not, even if you're against me on that point, it's not clear what obligations are being assumed by Deyaar, because there were two sets of obligations. There was one set of obligations, namely the obligations under the Murabahar agreement. And there was also a separate advance, which is 81 million dirhams, made on the 12th of September by NBC to Taaleem, to enable it to pay the next instalment of the purchase price under the tripartite agreement. And at the trial, as far as I can tell, there was no consensus that there was any contractual obligation to pay that. Indeed, the parties, and I'll take you to that, the parties, NBC was saying there's a liability to pay this in the contract. Taaleem, as far as one can say, there was no contract, because in fact Taaleem had refused to enter into a new Murabahar agreement, and there was a concession made in the opening submissions that there was a restitutionary liability to repay it. But there is a difficulty there. I mean, that's a liability which is conceded at a trial in 2013, which wouldn't have been necessarily apparent at the time. And there is also a difficulty, we say, as a matter of law, in making a finding, if indeed one was made, that that obligation was passed to Deyaar. And there is, in my submission, considerable uncertainty in relation to what obligations claimant, Taaleem and NBC were referring to at the trial. Now, it may be that no, and if one then comes to reconsider how the judgment, if you're prepared to do so, should be reframed, one has to make it absolutely clear for the purposes of the order what obligations it is being said that Deyaar has assumed. And that, it seems to me, my Lord, is a proper quantum point. Have a wider submission about the general uncertainty in relation to NBC, but that is a proper quantum point. Which of these obligations was passed across, which were not? And there is also a subsidiary point, because your Lordship may have noticed, that the Taaleem is claiming interest at 5.5% under the Murabahar agreement, and also late payment charges at 2%, and that adds another 50% to the amount of the claim. And those obligations are just not in the Murabahar agreement at all. And that's a point I will be taking it to. So, and again, in my submission, that is a true quantum point. So it may well be that you reject my submissions. I have the general submission that there was a complete fog, really, in December 2008, I beg your pardon, about what, if anything, Deyaar assumed to Taaleem, and there were these uncertainties. But I also make two distinct quantum points about the obligations, and that it is said that we're being asked to assume. And if one looks at the order, in paragraph 2, in my learned friend's 328.
Sorry, NBC's proposed order.
Yes, 328.
Yes. Paragraph 3, is it?
Well, it's really paragraph 1A. If you look at B, they say claimant's obligation to repay the first defendant the principal monies advanced to finance the purchase of the interest, as well as Murabahar profit and late payment charges. Well, it may well be appropriate to make a finding that there was, the Lordship may make a finding that it's the liability under the Murabahar agreement was transferred. But when one looks at where one locates those other obligations, it's not clear at all. Particularly the Murabahar profit and late payment charges. And I'll take you to that in some detail. My primary submission at the moment, my Lord, is that it is necessary for you to clarify the judgment for a number of reasons. The first is because the words "a concluded agreement for transfer of Taaleem's interest in Sky Gardens to Deyaar on the 4th of December 2008 is, on its face, no more than that. And we invite you to make a declaration in those terms. We also ask you to decide or make it clear what the terms of that agreement were, and we invite you to find that those terms can be located in the amendment to the tripartite agreement. And we ask you to recognise that that does not necessarily carry with it the obligation to repay NBC, because that's a different contract. And all I'm trying to do here, my Lord, is focus on the term, on the judgment itself, and what can be spelt out of paragraph 98, which is the conclusion.
Yes, thank you. Well, I'm not quite sure what sort of phase you've reached. I'm going to break reasonably soon. That's extremely inconvenient. And so,
Well, that's a
take
convenient.
another 10 or 15 minutes if you want, but I just...
Well, if you would like, if that's, I was going to start developing the argument really with reference to documents, my lord. If that's going to.
Well, then we'll take a break if we may. Thank you very much. We'll see you tomorrow. And when do you want to start, Chad?